Hi, this is Professor David Opterbeck, and welcome to the next lecture in our new media law class. And in this class, we're going to be talking about the law relating to video games. Obviously, there's a lot we could talk about concerning video games. We could do a whole class, a whole semester, I think, just on video games. So we do have to focus our discussion on a few aspects of video games. I've chosen to do video games in this class because I do believe that when we talk about new media, video games are certainly one of those areas of media that is becoming increasingly important. And when we have talked about convergence, which we have talked about all semester, I think video games are a place where issues relating to convergence are increasingly becoming really important. And you'll see even a little bit of that in our discussion today about trademarks in virtual worlds, about the Digital Millennium Copyright Act in virtual worlds. I think you're going to see the structure of virtual worlds, games, activities that are in-game, out-of-game, media centers like the Xbox, which hasn't quite gotten there yet, but wanting to be the hub of all the communications in the household. All of these things are going to continue to be important themes. So what are we going to talk about in this class? We're going to talk about Coppa, which is the Child Online Privacy Protection Act. We're going to talk about ratings of video games and the First Amendment. We're going to talk about the Digital Millennium Copyright Act and virtual worlds, the in-game use of trademarks, and the copyright status of video game characters. And you'll see as we talk about some of these things that some of the law, as we'll talk about Coppa. I'm actually going to show you in a moment a video from the Federal Trade Commission that lays out a very nice summary of Coppa and its requirements. And that, of course, is a federal statute and a regulation related to the statute. When we talk about the First Amendment, we'll be looking at a U.S. Supreme Court case. So there we have some law that's established at a very high level. Some of these other cases we'll be looking at might be from one particular circuit or district court cases, and I think you'll see that some of the law in those areas potentially is in flux. So the first thing I'm going to do is I'm going to cut away from our presentation here, and I'm going to show you this video from the Federal Trade Commission relating to Coppa.
When it comes to information that companies collect online from kids under 13, parents should be in control. That's the thinking behind the Children's Online Privacy Protection Act and the Coppa rule. The rule has been in place for years, but the Federal Trade Commission, the nation's consumer protection agency, has revised Coppa to keep pace with technology. If your company has been complying with Coppa, the basics still apply. You still have to give notice to parents and get their verifiable consent before you collect, use, or disclose personal information from children under 13. You still have to keep kids' information secure. And the revised Coppa rule retains safe harbor provisions so that groups can submit programs for FTC approval. But 5 key changes to Coppa take effect July 1st, 2013. Here's what your business needs to know.
I'm Peter McGee, an attorney with the FTC. So what's new about Coppa? The first important change is that the FTC has revised some definitions to expand who's covered by Coppa and the kinds of information that require companies to comply with the rule. The rule has always applied if you operate a website, an online service, or an app directed to children under 13. It also applies if you have a site, a service, or an app directed to a general audience and you have actual knowledge that you're collecting personal information online from kids in that under 13 age group. Revisions to the rule make it clear that Coppa also covers an operator of a child-directed site or service where it allows outside services, like plugins or advertising networks, to collect personal information from visitors. In addition, if a plugin or ad network has actual knowledge that it's collecting personal information through a child-directed site or service, the plugin or ad network is covered by Coppa too. The upshot? The rule applies to companies that may be new to Coppa compliance. The FTC also has revised the definition of the types of information Coppa covers. The rule has always applied if companies collect certain kinds of personal information from kids under 13, like their first and last name, a home address, a phone number, an email address, online contact information, or a screen or username that functions as online contact information. But the FTC has clarified that definition. The Coppa rule covers geolocation information that can identify a street name and the city or town. And we've expanded the rule to include photos, videos, and audio files that contain a kid's image or voice as well. Something else covered under the revised Coppa rule: persistent identifiers that can be used to recognize a user over time and across different sites or online services. But there's a notable exception here. Coppa's parental notice and consent requirements don't apply if the identifier is used just to support your site's internal operations. Take a look at the rule for more about the meaning of internal operations in this context. Another change to Coppa relates to what operators need to tell parents. It's still the law that you have to notify parents directly and get their verifiable consent before collecting personal information online from their kids. But now you need to know to put certain key pieces of information up front within the notice you send. You'll want to read the rule for the specifics, but the big picture is that it's not enough just to give parents a link to something on your site and expect them to figure things out for themselves. This change will make it easier for parents to get the important details they need when they need them. The rule also streamlines what you have to include in your online privacy policy about your information practices. The third change involves new ways to get the parental consent Coppa requires. In addition to the methods already in the rule, including FTC-approved safe harbor programs, Coppa now gives businesses more ways to get a parent's okay. For example, electronic scans of signed consent forms, video conferencing, the use of government-issued IDs, and alternative payment systems, assuming they meet the same stringent criteria as credit cards. The sliding scale mechanism of parental consent, often called Email Plus, is still an acceptable method for operators that collect personal information just for their own internal use. Technology changes quickly, so to encourage innovation in this area, the revised rule sets up a voluntary process for businesses to get FTC approval for other methods of parental consent. The fourth change strengthens provisions for keeping kids' information confidential and secure. Under the revised rule, operators must take reasonable steps to make sure that before releasing information to service providers or other third parties, those companies are capable of maintaining the confidentiality, security, and integrity of the information. It's not enough if they just talk the talk. You also need to get assurances they'll follow through. Under Coppa, you can retain kids' personal information only as long as it's reasonably necessary. And when you dispose of it, you have to take reasonable steps to protect against unauthorized access. The fifth change to Coppa deals with additional monitoring of self-regulatory safe harbors. The new rule strengthens the FTC's oversight of safe harbor programs. It requires them to audit members and report the combined results of those audits to the FTC every year.
That's just a brief recap of changes to Coppa. For compliance resources, visit the Children's Privacy page on the FTC Business Center at business.ftc.gov. For more how-to guidance, read the Children's Online Privacy Protection Rule. And complying with Coppa, frequently asked questions. Have a question that's not answered there? Send us an email at coppahotline@ftc.gov.
Okay, now that we're back, let's talk about video game ratings and the First Amendment. And the case I gave you to look at is the U.S. Supreme Court case Brown versus Entertainment Merchants, decided in 2011. And the issue in this case was a statute in California that was attempting to require, as a matter of statute, that video game makers include specific kinds of warning labels on the video game packages. And the rationale for the legislation was that video games can be very violent, and the legislature cited some studies suggesting that the violence of video games can have a negative impact on children who play video games. So it was cast as a child protection measure. And as you can see, the Supreme Court decided that this statute was unconstitutional under the First Amendment. In an opinion which might surprise you a little bit, written by Justice Scalia. And I think there's an interesting tension as you look at Justice Scalia's majority opinion and you look at Justice Thomas's dissent. The two originalists on the court really took different views about what the original meaning of the Constitution was, and that really influenced the way I think the different coalitions of justices lined up ultimately in deciding this case. So a first key thing that you need to note is that the court clearly unambiguously says that video games, like any other kind of speech, qualify for First Amendment protection. So there had been some arguments that video games is a certain kind of entertainment, is more interactive, perhaps doesn't qualify for the same kind of speech protection, and the Supreme Court says no, video games clearly qualify for First Amendment protection. Justice Scalia says in this majority opinion that speech about violence is not considered obscene speech under the First Amendment. Now, why is this an important finding? It's not as though obscenity can be sort of necessarily flat out banned by government under the First Amendment, but as you know from constitutional law, there's a long line of cases dealing with obscenity and pornography in the First Amendment context. And the Supreme Court has recognized that there are circumstances in which a government may have an appropriate interest in regulating obscenity and pornography, and in particular, that interest becomes very strong when the regulation relates to the protection of minors. So there are cases about suggesting that pornography itself can't be simply banned. It can be regulated under certain kinds of circumstances. Child pornography can be flat out banned. So there's Supreme Court case law talking about that. Similarly, obscene speech, or so for example, a television show depicting sexual act or something like that that's short of pornography, perhaps, can't usually be flat out banned. It can, under some circumstances, be regulated, and in particular, as that kind of content is made available to minors, it can be regulated. But by making this move of saying that speech about violence is not obscene speech, that whole line of cases is taken out of play. And ultimately, Justice Scalia decides that strict scrutiny has to be applied to this statute involving protection of minors and warnings on video games. As you know, very often, probably more often than not, when strict scrutiny is being applied, it's very difficult for a statute to pass muster. And this statute ultimately does not pass muster in the eyes of the majority. So notice Justice Scalia's way of approaching the question of how the First Amendment should be interpreted in relation to speech about violence directed to minors. And he's consistent with the way he interpreted the Constitution. He would look at historical tradition of how a particular kind of area of conduct was understood, and particularly understood at the time of the framing of the Constitution. And he says there's no long-standing tradition about concerning speech about violence to minors. In fact, he says there's many examples going back to the old fairy tales that show that minors are often exposed to violence in the literature that they're exposed to. And Scalia doesn't buy the argument that video games are different than Grimm's fairy tales or something like that in a material way. Even though video games are more interactive, you're playing the game, you're more immersed in the game, Scalia said this really doesn't make any difference in terms of the First Amendment analysis. It's all a form of speech, it's all a form of literature, and it's not inconsistent with the fact that children historically have been exposed to violent imagery in the literature that they're exposed to, and this was always considered a part of the sort of speech that the First Amendment would protect. Now, there's an interesting concurrence by Justice Alito, joined by Justice Roberts. And if you notice, Alito says, well, I agree with Scalia insofar as this statute is very vague. Its definitions about what would fit into different categories of violence and have to get a different kind of rating is too vague, and that's a problem. But Alito says video games are different. Video games are interactive. A player of a video game is much more immersed. The player is actually carrying out some of the conduct through the player's avatar or character in the game. And the violence in the games can be very extreme and intense and graphic. And I think, those of you watching this lecture who are or have been gamers who have played first-person shooters or other games like Grand Theft Auto, other games like that, that there's a fair amount of truth in what Alito is saying. Even though it is, you're playing a game, it is stylized in many ways. Still, games can be pretty graphic, and you are playing. And so Alito says he's not willing to say one way or the other how this would turn out if a statute were more narrowly drawn. He just wants to flag this issue and suggest that it's possible a more narrowly drawn statute could survive because of this concern that video games are different. And then you have Justice Thomas's dissent, and this is this place where it gets interesting, and you actually, I think, on a fair amount of occasions, you saw Thomas and Scalia disagreeing on their approach to originalism and their interpretation of original meaning. And Thomas says the original meaning would be that no one can speak to a child without going through the child's adult parent or guardian. So at the time of the framing, Thomas says you wouldn't simply go up and speak anything to a child without going through their parent or guardian. So an interesting bit of historiography, whether it's accurate or not, I don't know, but it kind of raises a difference in how they would have approached it. But of course, core takeaway for us, majority opinion, video games are speech, and video game violence is not in the category of obscenity when it comes to First Amendment analysis. How does this all play out? I mean, if you do play video games at all, you'll know that they do have warning labels on them, and I have up here on the screen what those warning labels look like. I do know as a parent, now my two of my kids are older, or in their 20s or almost in their 20s, so this isn't really a place where I get involved anymore, but with my son who just turned 15, I do get involved here, and I am concerned if he wants to buy a game that has an M label on it. I'll look very carefully at what that game contains, and more likely than not, I'll not allow him to buy it or steer him away from it. But how does this work now? It is entirely voluntary. So the ESRB, the Entertainment Software Rating Board, is an industry organization that has come up with these labels. Why does the industry do this? Partly a public relations measure, partly an effort to stave off other legislation, whether at the state level or nationally, that might be drawn up more narrowly in an effort to avoid a constitutional problem. Also not an issue I think that the industry, even if they end up winning it, really wants to be seen litigating. So you can ask about whether these labels are really effective or not, but this is the system we have in place now.